This is Judge Deidre Davis, Judge of the 270th District Court. Today is June the 18th, 2026. We have Team Legal Eagles with the presenter ELIZE Mendoza, a 3L law student at South Texas College of Law. She is going to give us her presentation of the Texas Rules of Civil Procedure 167. We'll have a competing PowerPoint in a few days, but today we have future attorney ELIZE Mendoza. One moment, you are welcome to go ahead and share your screen and begin your presentation. Thank you.
May I please record?
Yes.
Hello, everyone. Today, as mentioned by Judge Davis, my name is ELIZE Mendoza. I am a 3L at the South Texas College of Law. And our group, the Legal Eagles, put together a presentation over the Texas Rule of Civil Procedure 167. And this deals with offers of settlement. And in the Legal Eagles group is myself, Paul Patricio, he's a 2L at South Texas, Elmer Berganza, a 2L South Texas, Aaliyah Skipper, 2L at South Texas, Jorge Torres, a 2L at South Texas, Clarissa Mullen, 2L South Texas, Sophia Villarreal, a 2L South Texas, Janine Catacoy, a 2L at South Texas, Shemaya Fields, a recent TSU graduate, Nick Lord, a senior at the University of Houston, and Celia Orgaz, a high school student. Now, the purpose behind 167 is to encourage parties to settle cases early instead of forcing every dispute to go all the way to trial. It creates a financial consequence for parties who reject a reasonable settlement offer and then end up doing worse at trial. So, as we mentioned, if one side makes a reasonable offer, settlement offer, and then the other side rejects it, the rejecting party may later have to pay litigation costs if the trial turns out worse than the offer that they gave previously. So if you think about it like this, the rule rewards those who makes fair offers, and it also encourages to not have unnecessary litigation. However, Rule 167 does not apply across the board. There are certain types of lawsuits that this rule does not apply to, and that's like divorce cases or custody lawsuits within family law. It does not apply to class actions. It does not apply to workers' compensation cases, and it does not apply to any lawsuits that involve the government. And the reason why these types of cases are excluded is because these types involve unique policy concerns, or they have different procedural systems all around. Now, before anyone can use Rule 167, the defendant must formally invoke the rule by filing a declaration with the court, and this declaration must be filed at least 45 days before trial. And what this is saying is the defendant is telling the court we're choosing to use Rule 167 settlement process in this case. And again, this has to be done at least 45 days before the trial. Now, for a settlement offer to count under 167, it does have to follow strict formal requirements. First, it must be in writing. Secondly, it must clearly state that it's being made under Rule 167. It must identify all involved parties, and that means also identifying the parties that's making the offer, the offerer, and then the party receiving the offer, the offeree. It must explain exactly how the case is to be resolved, and it has to include all attorney's fees and any other costs that have been accrued up to that point. Lastly, it must also give the other side at least 14 days to respond to the formal offer. And the reason for these rules is to prevent any confusion and make sure that everyone clearly understands the terms of the offer that's being given. Now, with this rule, there's also limits on timing and certain conditions. For example, parties cannot surprise each other with settlement offers that are right before trial. An offer cannot be made before the defendant has filed that declaration we mentioned. And most offers cannot be made within 14 days of trial. An offer may not be made within 60 days after the appearance in this case, and that's either by either party, their first appearance. However, offers can include reasonable conditions, such as signing a release agreement. And if the receiving party thinks the conditions are unfair, they have to object to it in writing before the given deadline. Now, an offer under 167 also works like a contract offer. The person making the offer is able to withdraw it before it is accepted. To accept the offer, the other side must provide that acceptance in writing before the given deadline. If the deadline passes without the acceptance, then the offer is automatically considered rejected. And this rule also encourages parties to continue negotiating by recognizing successive offers. Now, what triggers, this is the part, the most important part of 167, it's the trigger. So if after rejecting a settlement offer, the rejecting party ends up doing significantly worse at trial, they're the ones who essentially who pays under this rule. And for example, if the claimant rejected an offer and recovered less than 80% of that offer at trial, then the judgment is considered significantly less favorable. If it's the defendant that rejected an offer and the final judgment is more than 120%, then the defendant is considered to have done significantly worse at trial. And this is the point where the litigation costs can shift. So what we mean by litigation costs under 167 can include the court costs, deposition expenses, expert witness fees, or reasonable attorney fees. And the idea is that if someone unnecessarily prolongs litigation by rejecting a fair offer, then they have to compensate the other side by paying those litigation costs. So even though Rule 167 allows the cost shifting, there are also important limits placed on that. And this rule prevents what we call negative winnings. For example, if a claimant wins $50,000 at trial, then under 167, it cannot, the litigation cost cannot be over that 50,000. And that's just an example, you know, if it's more, it can't be over that final amount. So 167 can reduce significantly or basically eliminate a recovery, but it cannot push the claimant into owing additional money beyond the judgment itself. And how this applies to the different parties, as we mentioned, if you're the claimant, you're the person suing. So if you rejected a good offer, you now have to pay the defendant's legal costs. And the court will just subtract that from your winnings. And because of the cap, the defendant cannot take more than what you've won. If you're the defendant and you rejected a settlement offer and the claimant won significantly more at trial, then you may have to pay their litigation costs. And those extra costs are also capped at the amount of the original judgment. Now, other important limits is that 167 prevents double recovery. A party cannot recover the same attorney's fees twice, once under this 167 and under a different other rule or contract. So this rule makes sure that you're not getting that amount 2 times. That's what it means by no double recovery. This rule also contains odor calculation formulas for cases that have been filed before September 1st of 2011, but those older provisions rarely apply today. And one important feature of 167 is that settlement offers are generally kept away from the jury. The jury is never told about these settlement negotiations because that could unfairly influence their decision. The rule allows courts to hold hearings to determine whether the litigation costs are reasonable. So that's also a good thing. In conclusion, 167 is designed to encourage fair settlement negotiations and discourage unnecessary trials. And I thank you for your time.
Thank you very much to our 3L student, ELIZE Mendoza. You did a spectacular presentation. We are going to end our recording. We're going to end our YouTube. Again, this is Judge Deidre Davis, the presiding judge of the 270th District Court, and we are excited about our law students. Thank you. Stop.